All right. Good morning, everybody. We'll give everyone a few minutes to join and settle in. Hello, hello. Good morning, everybody. Welcome to our Journey EB-1 webinar. We're going to wait a couple of minutes for people to join and get connected. All right, and please know that we do have a nice chat feature if people want to say hello, and we'd love to know where people are joining us from. All right, we've got Miami, Atlanta, Georgia, Orlando, California, Texas, Mexico. Amazing, amazing. We're from coast to coast. Detroit, New York City, Chicago, Utah, Toronto. All right. We're going north to south, Canada to Mexico, and from California to Miami. Amazing. Ecuador, Orlando, Boston, New Jersey, New York. Amazing, amazing. All right, everyone, we're going to wait one more minute for people to join, and then we'll get started. New York, Washington, D.C. Amazing. West Palm Beach, Florida, Virginia. Thank you, everybody, for joining us. Thank you so much. Virginia, New York City, Orlando. All right. Anybody else? Where are you joining us from? We're going to get started in less than 1 minute. As everyone continues to connect, we already have over 150 people connected with us. Amazing. Great turnout. Thank you, everybody. Orlando, Minnesota. Fantastic. And yes, as Julia mentioned, it's so nice to see so many familiar names, people that we have connected with and worked with in the past. Thank you so much for joining us. All right. Well, hello, everyone, and welcome to today's webinar, The Rise of EB-1, Key Trends and Strategies Attorneys Need to Know. My name is Joshua Wallace, and I'm the Vice President of Sales here at Journey, and I will be your host for today's session. And thank you to everybody for joining us. We see a wide range of immigration professionals from all across the United States and worldwide as well. Thank you for being here. Quickly, for those of you who may want to know a little bit more about us here at Journey, I'd like to very briefly introduce ourselves. Here at Journey, we partner with immigration attorneys and their clients to create high-quality business plans and supporting documents for immigration petitions, empowering international entrepreneurs and professionals in their life-changing endeavors. Our role is to help attorneys strengthen their clients' cases by providing clear, professional, and persuasive documentation tailored to each visa category. We also provide case preparation services, supporting immigration attorneys by organizing client documents, drafting petition letters, and assembling complete, ready-to-file case packages. All right, and now, if you have been practicing U.S. immigration law recently, you have likely seen what many attorneys are experiencing. The demand for the EB-1 category is on the rise. At the same time, USCIS adjudication trends are evolving, making it more critical than ever to understand how to evaluate candidates, structure petitions, and anticipate potential challenges. which brings us to today's amazing session. And here to help guide us through the latest EB-1 strategies and insights, I'm joined by attorney Amber Davis, a highly experienced U.S. immigration lawyer who has helped professionals, academics, and entrepreneurs successfully navigate this complex category. Amber will be sharing her perspective on adjudication patterns, petition strategies, and how attorneys can position their clients for success. Welcome, Amber, and thank you so much for being here with us today.
Thanks, Joshua. I'm super excited to join this webinar.
Amazing. And just before we get started, everyone, to let you know, if you have any questions, you'll see there is also a questions button that you can click and ask, and we will try to leave time at the end of the session to answer as many as possible. And there is also 1 CLE credit available for today's session, and we will announce the code at the very end. All right, without further ado, we're going to jump right into it. Amber, can you please start by giving us a nice brief overview of the EB-1 visa category?
Yeah, so the EB-1 visa category is actually a little bit diverse. Everyone thinks of it as being the extraordinary ability visa, but there are actually 3 different types. So there's the EB-1A, which is extraordinary ability, the EB-1B, which is for outstanding professors and researchers, and the EB-1C, which is for multinational executives and managers, mostly those who are coming through on the L1 visa, although they don't have to be here on the L1 first. So there's a lot of people that qualify for the EB-1 category in these various categories, but typically when you're out in the world and you're hearing about EB-1 and you're hearing about EB-1 trends, most people are talking about EB-1A. I will say EB-1B seems to be really underutilized. So if you are an outstanding professor or researcher, or if you're representing those clients through the companies that you work for, you should definitely look into that category a little bit more. It's much easier to get an EB-1B than an EB-1A. And then, of course, EB-1Cs are for the intra-company transferees. So they have to have worked for a company abroad in a managerial or executive role and then transferred to the U.S. to work for that related U.S. entity. So it's really broad, but it is the top level visa category, which is why it's so important and why it's so desired, which we're going to get into later in this presentation.
Absolutely. Thank you so much for that brief introduction, Amber. And you did mention a little bit of this already, but can you dive a little bit into some of the main differences between EB-1A, EB-1B, and EB-1C, and talk about what kind of people you see applying for those? Which clients do you typically work with? What are your recommendations there?
Yeah, so they really are not interchangeable. They are very distinct categories in the law. EB-1A is for extraordinary ability professionals, and they can be in a variety of fields. They can be in business, in arts, in sports, in science, engineering. Any of these categories will qualify for EB-1A. But the defining factor is that the person needs to prove that they have risen to the top of their field and that they have experienced sustained acclaim throughout their professional career. EB-1A can be self-sponsored, which makes it, I think, the most desirable. It's essentially the highest level visa that you can obtain here in the United States, and it gives people a lot of flexibility and freedom to plan their own pathway. EB-1B is for those outstanding professors and researchers. So they have to show that they have earned distinction in their field. They have to demonstrate that they meet certain criteria. And for researchers, even in those researchers who are in industry, they need to be able to demonstrate that their research record is recognized. Sometimes it doesn't work as well for those who are working at super private companies that don't want to publish any of their research and are very, very private. But EB-1B, I think, is not as popular as it should be. There are a lot of people who qualify for EB-1B whose companies really should be looking at that category, especially now that EB-2 national interest waivers are so backlogged. We will get into that a little bit later in this presentation too. And then EB-1C is for those multinational executives and managers. They are typically people who have worked all over the world. Sometimes they'll just have worked in one country and then another, but they usually have a really international professional work profile. And the company needs to sponsor them as well. EB-1B and EB-1C are both company sponsored. So I get clients all the time coming to me and saying, you know, I qualify, I'm an international executive, or I qualify, I'm a researcher at my company, and their companies are actually refusing to sponsor them. So if you are representing companies, educating your company about why these categories can be really valuable for their employees is part of the job. A lot of companies have never done them before, and so they're not really familiar with those categories.
Fantastic. Thank you. Thank you. And then just building a little bit upon that, from your experience, what types of clients do you see that are best suited for EB-1 petitions? And I'd also be interested in knowing a little bit more about how you mentioned that they're not interchangeable, the A, B, and C. Do you ever find that any of these clients perhaps qualify for more than one of the different EB-1 types, or do you like to put them in that singular box? They're an A, they're a B, they're a C.
Yeah, it's a really good question. So I actually do work with a lot of Indian or Chinese nationals who have received an EB-1B or an EB-1C approval, but they want more flexibility for themselves. And since EB-1A is one of the very few categories that you can self-sponsor, a lot of them are trying to move up into that EB-1A category. Now, it's all the same timeline, but since Indian and Chinese nationals are backlogged, if an Indian national, for example, has an EB-1B approval, it may still be 5 years before their priority date becomes current. And maybe they just want to work for their company for 2 years and then move on. Having the EB-1A gives them the ability to move on with confidence so that they can still immigrate, they can still take advantage of their EB-1 priority date. I think companies get a little nervous about this because they like to retain their talent. It really is only an issue for Indian or Chinese nationals just because no one else is backlogged in the EB-1 category. But it's something that you may find your Indian clients asking for in particular. It's a very common strategy. It is hard to move into EB-1. So you can have an EB-1B approval and have no shot at an EB-1A. And same for EB-1C. You can have that approved and it can be a really solid EB-1C case, and you just don't have a case for EB-1A. So the categories are really distinct in that regard. For EB-1A, the defining factor is the person needs to have that sustained acclaim and broader recognition of expertise in their field. For EB-1B, they need to be doing solid research, and then for EB-1C, they need to have both the executive or managerial experience and the qualifying relationship on the corporate end from the company they work with abroad and the company they are working with in the United States.
Great, great. And are there any common industries, common backgrounds, common profiles that you are seeing either applying more than others or qualifying and getting approvals more than others?
So as far as qualifications are concerned, I would say that's not really a consideration. You can qualify for any of these categories in any field. I mean, EB-1B, maybe not because it's for professors or researchers, so that one's a little bit more either focused on academia or industry research in R&D type settings. But for EB-1C and EB-1A, any company, any field, any industry can qualify. So it's not so much a qualifications thing, it's more of an information and what people know kind of thing, because you will see trends in the industry, or I should say in the EB-1A industry, where a bunch of people in a particular company or in a particular field or in a particular sector all find out about the EB-1A or the EB-1C optional at once, and then they want consultations. I would say the big push in the last couple of years has been AI, but also tech in general, tech in a very broad sense. I think the layoffs, the massive layoffs that we all experienced in 2023 and continuing on to 2024 and present day have really shaped how tech workers are feeling about immigration. And so there's been a huge push, and there's been a lot of information, consultants, attorneys, new firms popping up around that trend. So yeah, I would say a lot of my clients follow that pattern right now.
Great, great. Thank you for that. And to finish with our introductory information, we may have some people joining us who are interested in getting into more EB-1A applications. For some of our watchers who may have never filed an EB-1 or maybe just a few and are interested in learning more, can you just give us a brief outline of the general application process from start to finish and how you handle that?
Yeah, sounds good. So the assessment and intake period, I think, is the most important. It's very important that the attorney is talking to the client, getting a sense of which criteria they fall under, whether that's the EB-1A criteria, the EB-1B criteria, or the definition of manager or executive in the EB-1C. So you will need to talk with the client, get a sense of their qualifications, and you will need to request some initial documentation, whether that's summarized in a resume with a bunch of links, or whether you actually get all of the documentation up front. You can usually tell if someone has a decent case, but the vetting process is not really over once you get that initial documentation. For all of these categories, you need to do a deeper dive into the qualifications and the meaning of those qualifications in the context of the person's specific industry, field, sport, art, or anything that they're applying for. So I would say intake takes us about half of the case prep time. It is pretty crazy. And we're constantly asking clients to upload more documentation on this point or that point, especially contextual documentation that tells us what the award is for, what the publication is targeted towards or geared towards, and a bunch of things like that. Once we do the intake, we actually draft reference letters for the client. And not all firms do this. Firms have differing views on the reference letters. So we will draft them for the clients. I know some other firms that will give some templates to the client and have them draft their reference letters themselves. And then some others ask the client to get unsolicited, I shouldn't say unsolicited, but like fresh letters without guidance from the referrers themselves. I draft them because I found that the letters are the most, they're the most important for getting facts into the record that aren't really interpretable from the documents themselves, like the meaning of a person's patent or the meaning of a person's paper in layman's terms. If you can get an expert to sign off on an explanation of that, then USCIS is more likely to accept that as evidence and actually understand what it means. So that's why I like to draft them. But those also go through a vetting process. So we vet them, the client vets them, and then the client's referrer vets them, make changes, edits, and all of that. From there, we will assemble the document package, and we're often adding contextual documents to that package. Like there are a lot of things you need to prove for all of these categories. For EB-1A, for example, you need to prove that the person has worked for a distinguished organization if you're claiming that particular criteria. So you need to pull information about the company's awards, reputation, economic standing, and all of that. So we're adding a lot, we're sorting them, we're trying to figure out how to present the case in a way that USCIS can digest easily, and that showcases the client's qualifications. From there, we draft the petition letter, and that's a summary of the entire case. And then we will print everything and ship it off to USCIS. And while that should be the easy part, it's often not. These petitions tend to be really big. I would say typically they're at least 800 pages. I certainly submit cases that are closer to 2,000 pages a lot. So it's a pretty big feat, especially for EB-1As and EB-1Bs. EB-1Cs are a little bit less. EB-1C is more of a definitional based process, so those packages are lighter. They might be 400 pages instead of the 800 to 2,000, but all of them are a substantial amount of work.
Amazing. And do you have any tips and tricks for organizing 800 to 2,000 pages, getting those all ready?
So always look at it how you think the USCIS officer would look at it, and try to figure out what is valuable about a particular document or set of documents. And when you're drafting your exhibit list, don't just say what the document is, but give some context or some meaning to it. So don't just say the title of a paper. You want to say the paper authored by client in prestigious X journal, on this particular original contribution topic, titled, and then put the title. So you're giving the officer some context. I often tell practitioners, you never know what USCIS is really going to look at or emphasize in the case. Adjudicators all have their own processes, methods, and everything for looking at these cases. So you can put together a beautiful petition letter, but some officers probably don't read them. Some officers, I think, look at the exhibit list and look at the client's resume and make their decision based on that. So you want your exhibit list to actually have the arguments for the case in it. You want the client's resume to look really good for the EB-1A and have the main points in it. You also want the officer, if they just flip through the exhibits, to understand the structure of the case and the arguments as well. So try to make it as easy as possible. I don't think the new system that USCIS has makes it very easy, because USCIS is just scanning these into their system. And I've received RFEs saying this document's illegible. I go look at my scan and it's perfectly legible. So I know it's an issue with their scanners, but that still goes back on you, even if it's an issue with their processes and systems. So, you try to make it as easy as possible, but I will say I can't wait until they come up with some kind of electronic filing system where we can just upload the evidence under each criteria, and have some assurances that USCIS will actually consider it under each of those criteria.
Absolutely. We weren't currently this there, but hopefully someday we'll see electronic filing coming soon.
Mm.
And then breaking down a little bit some of the different types of people you see applying for EB-1, academics, professionals, entrepreneurs, artists, athletes. Do you do anything different when filing those petitions? Do you have any different success factors based on the person's specific background and how you handle things with filing everything?
Yeah, so when I'm assessing the cases, I do tend to think of the cases in certain archetypes. And different things matter for different archetypes. This is going to be true for EB1C and EB1B, but I'm going to focus right now just on EB1A as kind of an explanation. So when I'm looking at a scholar or a researcher who wants to apply for EB1A, they're claiming that they're the top in the particular field of research. And so the research really is the most important thing in that case. It's what I would refer to as an anchor criterion. The authorship and the original contributions that that person made are the anchors for the case. They're the thing that USCIS is going to expect to see and will demand to see. So if you're presenting a case where those two criteria are the weakest, the case is likely to fail. Even if you're claiming that the researcher meets 6 criteria, if they have a publication record with only 10 papers, only like 90 citations, and then their original contribution isn't that significant, if they're claiming to work in the field of, let's say, cancer research, and if they are claiming that they are a top expert in cancer research, it's not going to fly with USCIS, because they're comparing those cases with other cases that have hundreds of papers, thousands, if not tens of thousands of citations, top professorial appointments, and like really prestigious accolades. Academia has lots of prestigious things, and if you don't have a lot of that on file, the case is likely to fail. So I will encounter researchers that can meet 6 EB1A criteria, but the case just doesn't look good because the anchor is not that good. The research, the primary reason for their qualifications, is not that good. Flipping over to a different scenario, if I encounter an industry professional, so someone who is, for example, a senior manager at a major company in the United States, I am expecting that we will be able to claim leading or critical role, and that will be the anchor criterion. And if they are claiming that they've risen to the top of the industry and they can't claim leading or critical role or original contributions, I would say one of those two, then something is probably wrong with the case. Like, they can have lots of media, lots of judge roles, a few articles, memberships, awards. They can have all of these things. But if the main reason that they are an expert isn't part of the criteria, if it's not the anchor criteria, then the case doesn't really make sense to USCIS. But if you compare and contrast the researcher and the industry professional, you wouldn't expect a researcher necessarily to claim leading or critical role. That criteria is not really going to factor in. And then vice versa, you wouldn't really expect an industry professional to be claiming authorship or doing peer reviews or those kinds of things. Sometimes they do, but that's never the important part of the case. It's just incidental. It's what I call a checklist item, where they say, okay, yeah, USCIS, I did these things, you should check it off the list, but it's not the reason that the person is extraordinary. So looking at the archetypes, it helps you sort everyone according to field. You really have to understand what matters for that field, what actually puts them at the top of that field? What do other professionals in that field consider to be at a really high level? And USCIS does understand this. They do evaluate cases this way. I don't know that they've ever come out and said it. I don't know that their guidance really has any of that. But you can claim authorship in an industry professional case based on 3 papers, and USCIS will give it to you. If you try to do the same thing for an academic, they're going to really resist giving that to you just because it doesn't make sense in that context.
Great, thank you. And before we jump to the next topic, Amber, just doing a little interaction here with our audience.
Sure.
That I'm reading the chat. Martin mentioned he believes USCIS would prefer not to see 2,000-page submissions. Do you have any comments on page limits, whether they exist or are just a general thought? What's your theory on how many pages are acceptable to file, and is a certain limit too many? Is a certain amount too many?
Yeah, so I mean, I put 2,000 just because that's what the largest FedEx box can handle, and I don't feel that it's reasonable to do more than that. I do really try to cut them down further. The main issue is that the agency says that they want certain things, and then they do the exact opposite. So I have had officers in an RFE response say that they only want the first page of the person's authored articles. I only saw that once. I've received numerous other RFEs where the officer said, you only submitted an excerpt of the article. We need the full article. And so I ended up submitting, 1,000 pages of the person's published work, even though it's easily accessible on Google Scholar where you can just click the article and pull it up. So you never really know what the officer is going to accept. What you do have to do, though, is make sure that you're submitting a case that contains evidence that supports all of your points. So you can excerpt it to some degree, but I am skeptical that USCIS will always accept excerpted evidence, because I do get a lot of RFEs demanding the full documents. So yes, I know that any reasonable adjudicator will not want 2,000 pages. They will want a more easily digestible petition package, but that's not what their RFEs say. So I think USCIS kind of shoots itself in the foot a little bit and makes its officers' jobs harder when it's not working with us to some degree. Like, it just let me just say, we should be able to just provide a Google Scholar link and say, look, USCIS, go click on these articles and you can see what they are. USCIS officers, if they're doing their due diligence, are going to be doing that anyways because they want to see what's out there publicly. And the fact that we can't do that makes me a little bit annoyed. But I do think changes are coming. The question is when. They are setting up for e-filing. I just don't know when.
Now let's shift focus a little bit and jump into something I know a lot of people are going to be interested in. Any crossover between EB-1 and EB-2 NIW, and what kind of strategic considerations there are when assessing a client for one or both visa types. If you could please tell us a little bit about how you approach those cases where a client might be qualified for both EB-1 and EB-2 NIW.
Yeah, so typically a client will be coming to you, an individual client will be coming to you because they want a self-sponsored option. And EB-1A and EB-2 NIW are really the only two that are out there. I mean, there's EB-5, but it is a little bit different. So often I am doing a joint EB-1 and EB-2 NIW consultation, and I'm simultaneously assessing for both. I have certainly had clients who are only qualified for EB-1 and probably never would win an EB-2. If it's in a field that isn't of national importance and would be really hard to do. Some of them that I've done before, like casino gaming, never going to file an NIW based on that, but great EB-1A case if they've risen to the top of their field. Other times I get people who are asking me for EB-1, but I'm really pushing them towards EB-2 NIW just because they don't qualify at this time for EB-1. There are also cases where people come to me for EB-2 NIW and they are feeling, I don't know, a little bit down on their own qualifications. I'm like, this is the best EB-1 case I've ever seen. So clients will surprise you. I think clients don't really have a great understanding a lot of time when they're coming to you. Like they know what they want overall. They want the green card. But you will need to evaluate for both in order to guide them appropriately. I do recommend sometimes applying for both at the same time. It's not something that I recommend lightly because it's obviously more expensive and I charge a lot more if I'm going to file both. Most of the time it can be a waste of effort, but in some cases it does make sense. Just to give the person that kind of certainty that they will get on the green card track, even if they aren't assured of one or the other. But yeah, I work with a lot of clients who have really strong EB-2 and IW cases and then are maybe qualified for EB-1A or have a weaker but viable EB-1 case. And I'm having a conversation with a lot of those clients on whether or not they really want to push for EB-1 or whether they do EB-2 and IW and just stick with that. I will say the nationalities matter. So if I'm consulting with a client from India and they don't have a priority date yet, I'm telling them to do EB-2 and IW, even if they have a decent EB-1A case, because they need to get that priority date first. And then once they have that priority date, EB-1 is probably going to be backlogged 3 to 5 years for them. So they have time to build a much stronger EB-1A case, and it's likely a good strategy for them. For people from China, kind of the same, although the timeline, the backlog is less. So sometimes I do end up recommending the EB-1A. And then for rest of world people, if they have really strong cases in both categories, EB-1A obviously has less of a backlog. But if they have, a really weak EB-1 and then a really strong EB-2 and IW, I'm just recommending the EB-2 and IW overall.
And you touched on this a little bit. Our next question was, do you recommend pursuing both simultaneously? And if so, under what circumstances? Are there situations where you, the attorney, say, you know what, we have to apply for both at the same time? Or when a client applies for both, is it more them feeling better about submitting 2 applications instead of 1? What do you see going on there?
It's really rare for me to push for it and recommend it. A lot of times I'm telling people, if resources are no concern, yeah, it's great to apply for both. Like, why not? Have both backup options and all of that. But I do actually phrase it that way. And I say, if resources are if money is no concern, then do both. But I don't, throw that out there lightly, because usually when I'm talking to a client, money is a concern. These are expensive petitions. And even though we can do discounts if we're filing both at once, they are very different. And so the whole petition letter ends up needing to be redone or customized for each case. The document package as well needs to be customized for each case. So yeah, if money is no object, go for both. But if you want to plan this out and take it seriously, and then pick one or the other. And I usually guide the clients through making that choice.
Great. That's great advice. Switching focus a little bit again, Amber, we're going to jump into talking about how you qualify and evaluate clients, probably in your initial consultation with them. So when you're looking at a potential EB-1 case, are there any top great signals, green flags, if you will, that signal to you, hey, this is going to be a really strong petition?
Yeah, and again, I'm focusing this more on EB-1A. I think the principles are applicable for EB-1B and EB-1C, but EB-1A is what I'm seeing a lot of recently. It's like the big trending topic. Top green flags, lots of work experience, so longevity in the field, and I'm not really talking about 10 years. 10 years is really like the minimum. If you have 20 years, 30 years of experience in your field, that's a real green flag for EB-1A. High citation counts, especially a high citation count on a first authored paper, big green flag. You can create an entire EB-1A case around a breakthrough research announcement through a paper. So that's really good. A top award in sports or arts, really good green flag there. Again, you can kind of create the case around that. And I guess what I'm looking for green flags is I'm either looking for longevity and lots of experience, or I'm looking for some really standout element that clearly demonstrates the person is at the top of their field.
And then on the opposite spectrum, any red flags that you see that make you think it's not a great petition or make you cautious about filing?
Yeah, so there's a lot going on in EB-1 right now. There's a lot of scams going on in EB-1 right now, a lot of issues. a lot of people have jumped on the EB-1A profile building bandwagon, and they're really trying to like find a way to get there quickly. So they're looking for a shortcut, kind of a cheat sheet kind of thing. And so what I've seen a lot of pop up recently is, relatively junior or mid-level professionals are going for EB-1A. They're trying to get all of the criteria that they can. So they're claiming like 6, 7, or 8 criteria. And they have tons of different activities listed under each criteria, but all of them are done in the last 6 months to a year. And they don't look like super prestigious activities. Those cases are really rough. I will say a lot of them get approved, and that's why everyone has been hopping on this bandwagon. Sometimes USCIS doesn't do that much due diligence, and there are differing opinions among USCIS officers on what qualifies for EB-1A. Some of them really are just checking these off the list, and if you meet 3 criteria and have some reasonable claim to fame, they'll approve the case. Others are applying a much, much higher standard. So a lot of these cases do get approved, and I do counsel my clients, and I tell them that like it is definitely possible to get an approval here, but there are a lot of officers who would never approve that kind of case. And so it's a red flag to me because the clients often come to me saying, I have a super strong EB-1A case. I've done everything that I'm supposed to do. And I'm like, you probably need another 5 years just to develop that reputation in your field, get some more experience, get some better projects, get some more important accolades in your field. And they really don't like to hear that. I will tell people all the time, and I do think this is important. A lot of attorneys don't do this. There's no such thing as knowing that you are qualified for EB-1A. It's not a matter of being qualified or not. There is a threshold. So in order to be qualified, you have to pass a minimum threshold of meeting at least 3 criteria. But once you pass that threshold, the strength of your case is a whole spectrum. And I do think attorneys need to start advising clients a little bit more with that in mind. Like, it's not a matter of you qualify or not. It might be a matter of, I will take your case or I will not take your case, and here's why. But yeah, clients come to me all the time for like assurance that their case will be approved, and I end up telling them, well, 20% of officers might approve this. It's a guess. I don't know the exact number. I know that some similar cases have been approved, but most get denied. I think more of that conversation needs to be had in these self-sponsored petitions.
When you do accept a case, you believe a client has good qualifications and a strong profile. Do you have any tips and strategies for managing the client participation in the entire process? How do you typically handle that?
Yeah, clients, they all want something a little bit different. Some of them come and they want like regular checkpoints, like they want a weekly or bi-weekly call. I really struggle with that personally because I find that I'm doing the call and then I'm not working on their case, and then we keep talking about the case, but we're not actually writing the case, which is what we need to do. So I typically push back on a regular cadence, but that is just me. I know that some other attorneys and some other firms really thrive with having that regular cadence. And this is why it's important for clients to have a choice with firms. Like, they should have the choice to do the process that feels good for them. You want a good customer experience when you're doing these EB-1 cases. Typically, I will pull them in on a call for a couple different points. One when we're finalizing strategy, and then one when we're finalizing the actual petition. They can always schedule calls in between if they have something that they need to talk through as far as EB-1A documentation is concerned. Sometimes they'll talk to one of our paralegals about that instead. But you do need some communication during the course of the case. It is very, very important. Clients also have differing expectations on the level of edits and participation that they will be doing. And I haven't figured that out yet. I will say, haven't figured it out. Since every client wants something different, you have to try to respect what the client wants, because it is a deeply personal case. It's describing their career, their qualifications. But some clients certainly do try to get too involved, and everyone's pulling their hair out, and the case doesn't actually improve at that point in time. So yeah, I don't have the answers for that. still trying to be flexible and figure that out.
Great. And I'm sure everyone will appreciate the honesty there. I mean, we don't all have the answers to 100% of everything, and clients
Yeah.
are certainly complex, and each person is a unique individual, right?
Yes.
And talking about building a strong EB-1 petition, maybe seeing certain people that might not have the strongest profiles, the scams you mentioned of potential building of profiles. What do you recommend for putting together the strongest EB-1 petition? What kind of documentation do you need? What might be underestimated? Do you require academic publications? When might a business plan or professional plan be something that bolsters an application? If you can talk about the filing in general and the documentation you use.
Yeah, so documentation does differ across clients. We have kind of lists of things that we want to see for each criteria. So we're kind of treating each criteria like its own mini case. For each of the criteria, you need documentation that shows that the criteria is met, like the thing exists. So for leading or critical role, you need the employment verification letter. For an award, you need a picture of the certificate or the plaque or the medal or something. For an authored paper, you do want a copy of the paper. Now, whether or not you include the first page or the whole paper, it's a point of debate, but you need some proof that the paper exists. Aside from that, I tend to put in what I call contextual documentation. So this is documentation that proves the other elements. So going back to the paper, you not only need to show that the paper exists, you need to show that the publication itself is either a professional publication or a major trade publication. So you need to put in information about the publication and its targeted audience. Sometimes that's just from a printout of the journal or the magazine's website. Sometimes it's other papers. Aside from that, you want to be able to show the prestige factors. So printing off and finding some comparison points that demonstrate the ranking of the journal or the impact factor of the journal compared with the number of citations that the client has received on their paper. Any facts that you're going to cite in the petition letter, you do want them to be documented in the record as much as possible. And this is why the EB-1A petition packages are so large, because you don't just need to prove that there's a paper, you need to prove all of these other elements that USCIS is going to be looking at in the adjudication. As far as other documents that you create, I do work with a lot of EB-1A entrepreneurs. Some of them are abroad, some of them are here. Typically, if they're already working for their own company and they're kind of claiming EB-1A success based on their startup and how much funds they've raised and all of that, you don't necessarily need a business plan for moving forward. EB-1A is very focused on the accolades that you've already received. However, when people are abroad and they've never worked in the United States, I do typically recommend a business plan. And this is especially in the context of, a successful business owner or entrepreneur in their home country. They do need to demonstrate what the benefit they're going to bring to the United States is. Sometimes a short personal statement will work, but I have seen USCIS question that in the past, and so we do business plans either up front or in responses to RFEs. As far as other documents that you need to create, USCIS does have some suspicion on created documents. They have a whole thing where they want pre-existing corroborating objective evidence. So mostly I'm creating the reference letters, which then the experts are reviewing, editing, and signing off on. A personal statement from the client themselves, maybe a business plan or something to that effect, but not, well, I guess sometimes I'll submit some charts or analysis that we've created, but not much else. Everything else should be pre-existing.
Great. And shifting again, jump into a little bit of another topic that we have touched on, current trends and adjudication patterns. You mentioned clients from India, clients from China. We've seen EB-1 rise globally with interest recently. What do you think is driving this increase?
Definitely a function of the backlog. So you can do self-sponsorship through an EB-2 national interest waiver, and that's what a lot of people from rest of world countries would do in the past. Entrepreneurs could do this by showing that they were going to start a legitimate and functioning business here in the United States. People who were really recognized in their field could do it by demonstrating that they would continue in their endeavors here in the United States. So EB-2 NIW used to be a really great way for most of the top professionals in the world to immigrate. However, EB-2 NIW, or just EB-2 generally, became backlogged, and I think the backlog is actually a lot more significant than what the visa bulletin is showing. So I'm telling EB-2 NIW clients that if they're just applying now, they should probably expect to wait 3 to 5 years to get their green card. And for a lot of top professionals, that's just not really something that they want to do. And it's not something that they saw all of their colleagues do and all of their friends do in the past, because their colleagues and friends applied before there was a backlog. So it's driving a lot of interest in EB-1. There's also a consideration here that, rest of world immigrants will use the green card process to pursue permanent residence after studies here in the US. So there's a lot of people who have had really successful careers in their home country, and then they'll come to the United States for a master's or an MBA, that type of thing. They'll then have 1 year of OPT and 2 years of STEM OPT. So they need to be able to file their I-485 by the time their STEM OPT ends in order to have continuity in their work situation. EB-2 NIW is no longer offering that continuity, and PERM is not offering that continuity either. PERM actually used to be what people did before EB-2 NIW, and now there's no possibility of that continuity. So that's driving a huge demand for EB-1A. And EB-1A for people who typically wouldn't have needed it in the past. Things have really, really changed, where this is an important category for a lot of people planning out their status, whereas before it wasn't even something that I would mention or bring up or consider.
And any recent changes in the adjudication process for EB-1? I know you mentioned earlier a certain potential percentage of approvals that you're seeing and that many might get denied. What do you see in there as far as how the officers are responding, either with denials or RFEs?
Yeah, so trends are a little bit hard to track because we're always seeing the RFEs, and then you have a few months to respond to the RFEs, and then you get the decision. So sometimes I feel like there is a bit of a lag. I'm really hoping that I'm not seeing a new trend here. I will say we've seen a lot more RFEs recently. The first half of this year, our approval rates didn't really have impact, so things were proceeding along normally. But the recent RFE push definitely has me concerned that USCIS may try to deny more of these cases. There's also been some data released by some third-party companies that indicates a huge drop in approval rates. I'm not sure. Again, it's really difficult to figure out what data is accurate and what can be relied on. Even the USCIS data is not very good, and that's released even later, on a months-long delay. So overall, I would say there's probably more scrutiny. I just don't know how bad it is yet, and I am hoping that it's not quite as bad as the early indicators are showing, but the early indicators are not great right now.
Great. All right. Something definitely to consider, and we'll see what happens moving forward. All right. One more final quick question for you, Amber. I'll do a 2-for-1 question, and then we can jump into the audience questions because we have a ton. So we'll see how many we can get through. So just to wrap up our conversation before we get to the questions, any common mistakes you see, either whether from self-filers or from attorneys when doing these EB-1 applications? And then do you just have any general top pieces of advice for people handling EB-1 cases in general?
Yeah, I would say people emphasize the wrong things all the time. EB-1 is not, it's not some mystery. It's not like you have to get something specific to qualify. It is really obvious. You ask yourself the question, what makes this person extraordinary? And those are the factors that should be emphasized front and center. They should be emphasized at the very top of the petition. They should carry throughout that entire narrative thread. It's not really about figuring out all of the little pieces, although that is important. The main narrative is the main narrative. You don't need to change it. You don't need to mess with it. Also present your strong points and your strong evidence first. I do see a lot of attorneys who are, for example, presenting awards first or memberships first. Those are rarely the right categories to present first. You definitely want to emphasize the anchor criteria, the strong points up front. I'd say that's the biggest mistake I see, both with self-filers and with people who are going through less experienced attorneys.
Great. Perfect. Thank you so much, Amber, for all of that fantastic information and a very interesting and informative discussion. We've been doing 50 minutes and we technically have 10 minutes. We might go over a couple minutes as we do have a lot of questions. So I'll just jump into these and maybe we can do a little bit of rapid fire and see how it goes.
Yeah, sounds great.
All right. Some associations require and demand outstanding achievement to accept new members, but they do not disclose that. Do you have any best practices to show that this kind of membership would qualify?
Yeah, membership is a tough criteria. USCIS really hates granting it to people, and they are seemingly only looking at bylaws. And if that line, that language, that phrase is not in the bylaws, they're using that lack of line in the bylaws to deny membership. I don't think that's fair. I would really like to see this criteria litigated, similar to how authorship and judge were litigated, to make it more of a reasonable standard. But there's no magic key to overcoming this. It's just in the adjudicator's discretion. I would say even if the adjudicator is not going to accept the membership criteria, you can leverage that to show the final merits of the case. Like if the person is in a group with other top CEOs and that's obvious and apparent from the membership of the group, it shouldn't matter that the bylaws don't say outstanding achievements in them, right? So I sometimes do a comparison chart where I list out the members and I say what's extraordinary about each member, and then I'll do a letter from the membership organization verifying that you need to be a top CEO to join this committee or this board. And then I'll kind of leave it at that. And sometimes based on the RFE, I know that I'm not winning. Like I know that the evidence that I've submitted is not what USCIS is looking for. And at that point, I'm really just looking to emphasize that this person is at the top of their field. So yeah, it's sometimes a lost cause, unfortunately, and I don't have a magic key for that.
For concurrent filings, do you have an opinion on realistic timelines for I-140 and I-485 adjudication, considering the backlogs?
I rarely do concurrent filings. I really don't recommend it. I do, EB-1A with premium processing and then the I-485 in most cases. If you are doing a concurrent filing and you're not doing premium processing, I would consider it to be like at least a year in the making for both EB-1 and EB-2 and IW, because they have to approve the I-140 first and then they have to approve the I-485. It is a long process, so you should prepare your clients up front for that.
Many clients might insist on getting testimonial letters from previous colleagues and acquaintances. Do you think that there's a preference that these be written by people unrelated to the client that know of your work through the industry rather than a personal relationship?
Yeah, so this is another thing USCIS does, where no matter what you do, they can question it. If you submit all independent letters, they can say, well, these people don't really know your work, so how are they going to be relied on? If you submit all letters from people who know you, they're just going to say, well, these letters are full of effusive praise from people in your network, but who knows you outside of that network? It's always best practice, I think, to do a combination of both and have a slate of referrers where at least one referrer can address every kind of objection that USCIS can bring up.
Any opinion on how long a petition letter should be, the cover letter plus the legal argument?
Yeah, so when I am writing them myself, usually I try to keep them under 20 pages. I really like a 10 to 12 page petition letter. Sometimes, though, you need some additional context. And so, sometimes they can be 20 or 30. It's not really an industry standard. It is personal preference. I have read other petition letters that are 5 pages from other firms. I've seen other that are 90 pages from other firms. There's not a best practice there. I like them to be as succinct as possible while still covering what I view as the main points and putting in a narrative so that USCIS is analyzing everything in the context of that narrative. So if we're saying that the person is a top expert in this very specific field, I'm repeating something about the field every time I'm talking about the criteria itself.
Any trends on RFEs that you are seeing in these types of cases? Any specific points that keep getting brought up? Are you seeing boilerplate RFEs, kitchen sink RFEs? Any comments there?
Unfortunately, I think USCIS and its RFEs right now is not being very thorough. So I'm getting RFEs that question like one aspect of a criteria, but it ignores evidence that's already in the record, doesn't really analyze what's already in the record. It almost seems like it's an RFE just to issue an RFE and push the case along. So it's frustrating because it's really difficult to put together a responsive response. And it feels sometimes like you're rehashing or you're resubmitting a whole new petition. If you get a really vague RFE like that, sometimes you do have to rehash everything, and it is like submitting a whole new petition. But other than that trend, no super specific point, I would say.
For recommendation letters on behalf of the author, we got a question. Would you recommend reaching out to the author for their information about how they know the applicant? Do you like to provide recommendation letters from scratch? Do you provide samples? How do you handle that?
Yeah, typically I'll have the client fill out a questionnaire where they tell us how they know the person. They provide the person's professional CV. They talk about the main projects or the main contributions or the main points that the referrer would be able to speak to. And then I draft the letters. I do think it works better that way. Then I'll have the client send those over for review and signature.
Do you recommend combining the application letter with the table of contents?
So maybe, typically I'm doing the petition letter and then the exhibit list directly behind the petition letter. There are different ways to do it though. I do recommend a detailed table of contents. So we usually call that the exhibit list. And that should be an argumentative document in addition to the petition letter.
Here's a great question, something we didn't touch on. Can you talk a little bit about when someone comes to you on an L1A and directing them towards EB-1C? How do you handle that?
Yeah, it's rough because usually if they're coming to me about the EB-1C, it means things have not gone well at their company and they're trying to get me to coach them through how to talk to their company about doing the EB-1C. It's really unfortunate, but I've seen so many really strong EB-1C cases where the corporate attorney has come back and said, we have a really high standard now, you don't meet the standard, you don't have a case. And I'm looking at this, having filed many EB-1Cs in my past career. I'm looking at it and being like, this is a slam dunk EB-1C. I don't know what your company is talking about. I mean, that's my perspective. I represent only individuals, so that's what I'm seeing. If you are representing companies on this call, you might have reasons for advising the company that way. But it's been really frustrating. So typically when a client comes to me for EB-1C, I'm telling them what they should say to their company, but I'm also doing an EB-1A evaluation because I know at that point in time, their company is really not working with them or supporting them in a way that makes them feel comfortable. I will also say for any corporate attorneys on the call, the clients who are being denied the ability to file EB-1C, they want to leave at that point. Like that is not a good retention strategy for top talent. That is the most important thing to them, the most important thing. And so, yeah, maybe it's intentional sometimes if some people are being coached out of the company, but it's been a little frustrating over the past few months with the number of L1A consultations I've had where the person's being denied an EB-1C filing by the company.
If you have someone going from L1A to EB-1C, do you recommend getting a current letter from the employer abroad regarding the individual's experience with the qualifying entity abroad, or do you submit the older letter from the L1A application?
I've done it both ways. I do prefer to do a current letter. Oftentimes the older letters were done, 3-4 years ago, and USCIS is always updating what they want to see in their RFE trends and all of that. So whenever I've done these in the past, I've looked at the old letters and there's usually some things that I want to add. that is also something else, like referring back to the other question, there is a lot of scope creep where USCIS just wants to see more and more and more and more. And they might say they want to see less, but they're asking for more and more and more and more. And I'll look back at petitions that I filed 10 years ago, and they're so short compared to what we file now, like so short. And something needs to change there for the system to be fixed.
And that's a great segue into the next question somebody asked. How much time do you believe USCIS actually spends on cases? How does that affect your case presentation in 2025 based on the trends on RFEs and how much time they might spend reviewing a project?
Yeah, I think that USCIS actually gave some information about this at some point, or there have been some officers who have been talking about this. I don't remember what numbers they gave, but I have a feeling like 20 to 40 minutes is probably what they do for an average EB-1 or EB-2 NIW. I would be shocked if they spend more than 2 hours on a case. And I guess like for a super, super complicated case, maybe. But they're not spending a day and doing a deep dive. So you have to put everything out there for them. And that's why some contextual documentation is required so that they can just flip through. But you do have to manage the presentations to where the officer can tell what they're looking at. And it's why I think a detailed exhibit list or table of contents is super, super important, so that if the officer is looking at the documents and then the exhibit list, they can tell what they're looking at, but they can also tell why it's important for the case.
Great. Any considerations for clients living abroad versus living in the United States as far as how to approach their EB-1 filing and the various criteria?
Yeah, people abroad can definitely apply for EB-1A. I would say for EB-2 NIW, there seems to be a preference for people who are here, slight preference, like not a huge preference. But for EB-1A, in my experience, there hasn't really been higher standards or different standards for people living abroad. And that makes it a really, really good category for people to look at. I would say understand the timelines. Depending on what country you are in, the visa stamping timelines, the consular process after the EB-1 approval can be vastly different. But yeah, I mean, you have to show you meet the criteria. Sometimes you have to provide a little bit more contextual documentation to show why a certain accolade is important in your country, or why something is internationally renowned if it's not really known in the US. The kinds of accolades and opportunities that you present in the case might be slightly different than what USCIS sees for an average US-based petitioner, but it doesn't seem to disadvantage you all that much. So they're really viable cases.
Do you have an opinion on premium processing?
Yeah, I'm all for premium processing, and I know that's not what a lot of other attorneys are saying right now. The trends for the next 4 years or so, in my opinion, will only get a little bit worse or worse. I mean, we'll have to see if they actually revamp the rules themselves. There could be some improvements to the program, but filing and regular processing, expecting everything to be a little bit lesser as far as the scrutiny, I don't know is a really good strategy. So I preference getting the quick decision and then being able to adjust and make plans based on actually getting that decision. I do think premium RFEs are a little bit less detailed. So that's what I was saying about, the RFEs questioning one weird aspect of a criteria and not really looking at the documentation. And I think that's a function of the limited time that the officers have. But I don't know that the rate of RFEs is all that much higher. I do agree it's probably a little bit higher. So if someone has a really weak EB-1 case and not an urgent need for an approval, I might recommend that they do regular processing. But when I'm talking with all of my clients, and again, all of them are individuals, the time factor is so much more important to them. And I think that that's really it's not really understood very well by a lot of attorneys. So I'm all for premium. I do the vast majority, I would say more than 90% of my cases are filed in premium processing. Yeah.
In terms of your internal timeline, once you have a majority of the client's documents and information, How long does it typically take you to prepare the entire case for filing? What do you tell your clients as far as timeline and how long that will take?
Yeah, also something that's a bit of a struggle. We are a newer firm. We have made major project management changes, like a lot, probably every few months. So typically I would want to do 3 weeks for drafting and delivering the reference letters, 3 weeks for drafting and delivering the petition letter. But there are so many different points where we hand it back to the client that it is really difficult to set an overall processing timeline on the EB-1A. I'd say if everything goes really well, it should take 3 or 4 months to actually retain the client and submit the case. But I certainly have some that take a lot longer than that, usually at the client's choice, sometimes on our delays. I have clients right now who haven't moved their case and it's been more than a year. And I'm just waiting for them to take the next steps and move the case along. I have others that we were able to file in 1 to 2 months, so it is possible if everyone is pushing through and there's good momentum. But I think a lot of clients really want to push things through and have unrealistic expectations on all of the steps that need to happen and the back and forth that needs to be allowed as well. So yeah, that's typical for us, but I will say the project management aspect is definitely challenging. And I know it's challenging for a lot of attorneys out there too.
Do you ever see people going from O1A to EB1A?
Yes.
And
Yeah.
any comments on that process, differences, potential for approval?
Yeah, it's a typical pathway. So once you are on O1A, you should definitely be looking at an EB1A. Getting the O1 doesn't seem to help all that much. So I will say there's not really any deference to the prior O1 determination. And USCIS, I think, has made that increasingly clear over the last few years. Whereas when I first started, if you got the O1 approved, you would probably also get the EB1 approved. That has definitely changed. That's no longer the case. But most people who have the O1 approved are already doing the things that will eventually lead to an EB1 approval. They might just need a few more years to, get more of those prestige factors and show that they've risen to the top of their field.
Do you use any immigration softwares that you recommend?
I don't know. Let me just say that's a big struggle. I recently built out our workflow on Monday.com and I really like that. I like the flexibility. I like the customization. But we did have to actually build that out. I don't know about out of the box stuff. Like I'm not ready to make any recommendations.
Sure. Have you done any EB1A for influencers or people who are heavy on social media, lots of views, etc.? Any comments there, tips or tricks or ways to handle those?
Yeah, I mean, I've had a lot of consultations and I have a lot of ideas for handling these cases, but I think I did one a few years ago and not really following up on that. I would love to work on more of those cases. I think that they are really viable. And I think there's a lot of interesting arguments that you can present. The nice thing about those is you have stats to compare with, right? USCIS really likes showing statistics that someone is at the top of their field and someone has actually received a lot of public recognition and acclaim. And so I think that they are really good cases. I know a lot of people will complain about that. I have PhDs and scientists who are saying it's not fair that these people can make up all this fluff online and be more qualified than me. I'm like, well, the EB1A was set up for a claim. Like, it's not based on expertise. It's not based on knowledge. It's based on a claim. So yeah, I do think they're really good cases overall.
Talking about entrepreneurs who are eligible, do you see any challenges there for people who are pure entrepreneurs applying for EB1?
Yeah, so many entrepreneurs want to apply before they've actually seen the success. Like they get a taste of success and they're on the trajectory and that they're going to make it someday, but they're not ready. Like they haven't actually driven the revenue. They haven't actually driven the funding. They haven't actually hired all of the employees yet. So a lot of them are very eager and I end up telling them, 1 or 2 years, wait till your funding deal comes through, wait till you get this award, wait till you get this revenue level. That's the challenge, I think, working with entrepreneurs. Aside from that, if someone has received some acclaim in their field, if their business is genuinely doing well, and if they have received a lot of recognition for it, they're really good cases. USCIS does, I think, like to approve entrepreneurs as long as the base qualifications are there.
Great. And we've gone about 10 minutes over, Amber, so I'm going to take about 2 or 3 more questions. And thank you so much to the people from our audience for interacting and being so interested in this topic. I will quickly mention, and I'll mention it again at the very end, we have put information in the chat how to contact Amber via her website and how to get a hold of her if you would like to ask more questions and reach out after the webinar. So a couple more topics, Amber. Best practices for RFE responses?
Answer all of the questions. So oftentimes I'm quoting the questions in the RFE response just to make sure that we are addressing all of the points. So answer all of the questions, but also provide, the overview of the argument and all of the contextual documents that USCIS needs. They are intensive. So again, they do end up feeling like little mini EB-1 cases in and of themselves.
Any experience with NOIDs and what might make you decide to respond versus refile?
I usually prefer to respond to a NOID. I'll refile if I think the NOID is completely ridiculous, but I'll usually respond. We're usually relying on expert testimony to respond. And we're saying look, all these top experts agree this person has good expertise. They've risen to the top of their field. They've received sustained acclaim and all of that. They're really short. You only have 30 days to respond, and usually you get the NOID 1 week in, so you only have 3 weeks to respond. So it's quite a process. But I do see good success rates in responding to NOIDs. Not everything is approved, but a lot is approved, even after a NOID. I tell clients all the time, an RFE is actually worse because they haven't given you the criteria, but in a NOID, usually they have acknowledged that you met 3 criteria, and they're just questioning the final merits. And the final merits is more of a persuasive argument. It's not that it's not that you haven't met the criteria. It's not that there's anything objective that's missing. It's just a persuasive argument at that point in time.
When you do a client consult, do you have any recommendations on how to gently let somebody down who might not be as extraordinary as they think they are?
Yeah, I give them the comparison points, right? If I'm encountering a researcher who has done some genuinely impressive stuff but only has 200 citations, I will tell them, look, USCIS is comparing you to a professor of 30 years who has more than 100 publications and 10,000 citations. So, I'm setting them up realistically so that they can see what USCIS is looking for, and then they can understand why I'm saying the case is weak. I also tend to be really optimistic about the future. A lot of the clients who come to me for EB-1 have the drive, they have the talent already, and they have a really strong base. And so I think they will qualify for EB-1A at some point in the future. And so I'm trying to give them some pointers on what they would need to do to build their profile up. And then I'll tell them, what, in 2 or 3 years, come back, work on these things and come back for an evaluation. You don't have to say absolutely no, never to any client. There are a couple where, I have recommended giving up on the EB-1 dream just because they have expressed a deep distaste for networking or doing anything outside of their 9-to-5 job. And that's fine. If you don't want to generate that acclaim, you're not going to qualify for EB-1, but we can talk about PERM, we can talk about EB-2 and all of that. But for most clients, they have a good basis. They just need to give it more time and more effort overall.
Awesome. Thank you, Amber. And we're about 15 minutes over. So one final question before we let you go. Do you have any recommended resources that you look at, that you read, that you watch to stay informed about all things, either EB-2, EB-1, recent trends, updates? Where do you get your main news from about these topics?
Yeah, so if you are an attorney, I'm an AILA member and I am on the business immigration listserv. I also do all of their AILA 8 type stuff. I have AILA link, so I'm doing a lot of research and keeping up to date there. I'm also signed up for the USCIS alerts, so I see all of that. And I'm periodically looking at what the regulatory agendas will be for the relevant agencies. That's really all there is to it. There's that, and then there's some chatter with other immigration attorneys. I do definitely follow other immigration attorneys on LinkedIn and on other social media platforms, so we can chat back and forth a little bit about trends from time to time. Aside from that, everyone should read the USCIS policy manual. I think that's very important. And they should probably read it regularly. I read it probably at least 4 times a year. It's not everything, that's for sure. Like, I certainly submit cases where the policy manual is not relevant at all, and we're actually making a totally different argument. But I do think it's really informative for how USCIS handles a lot of things. And so far, at least, the RFEs do seem to be really in line with the policy manual. That's not the case for EB-2 and IWs, I will say. But for EB-1As and EB-1Bs and EB-1Cs, it's very much in line with adjudications. So really familiarize yourself with that document.
Great. Thank you so much, Amber. And then just as any parting words that you may have, thank you so much for your time. If you want to let anybody know any parting thoughts and how people can follow up with you. And as I mentioned, we've posted some information about you in our chat.
Yeah. So for parting thoughts, EB-1 is something that I think a lot of attorneys get grumpy about sometimes, where they're like, why would my client think they're extraordinary? They're just not there yet. And to some degree, that's true. I talk with a lot of clients who are not there yet. And I do have those thoughts where I'm like, why is this person looking for EB-1? They should be looking at things that they are actually qualified for. But keep in mind that EB-1 is one of the only options, if not the only option, for these clients to have some kind of control over their own immigration future. And so they will want to pursue it. And giving them some pointers about how to get there in the future is good for everybody. And so I recommend taking a more encouraging approach about it. That doesn't mean you don't have to be realistic. You definitely tell the client the truth, definitely tell them where they stand now according to the regulations and trends and rules and all of that. But especially for my Indian clients, I'm looking at the backlogs and I'm seeing that the only way they will get a green card within their lifetime under the current law is to do EB-1A. And so, of course, I'm recommending EB-1A in that case, even if they're really far behind, even if I'm telling them it's going to take at least 5 years, maybe 10 years before they qualify. It's something that a lot of people need to plan for. And I think attorneys should cultivate more of an awareness about that. It's not that people are trying to cheat the system or get ahead. It's that they're trying to get a green card in a reasonable amount of time. That's it. That's the whole story, and gain some control over the process. There's a big push towards EB-1. There are a lot of fraud, a lot of scams. There's a lot of people who are not qualified who are looking for it. But keep the longer view in mind, and I think keep the motivations in mind as well, because everything does make sense.
Perfect. Great. What a great way to end our webinar. Thank you so much to Amber Davis, our fantastic guest, for all of her knowledge and educating us all about these important topics.
Thank you so much, Joshua. This was great.
Great. Thank you, everybody, for joining. We'll talk to you soon.